Imagine a small family business, a shop built over one generation. The bank's own expert valued its properties at more than 40 crore rupees. Then one day, those same properties go to auction at a fraction of that value. The family says they never received the notice. The men came before any court order. And when they went to the police said, "The matter is in court. We can't interfere." This is the story of the ant and the elephant. And over the next 8 weeks, I'm going to show you, step by step, how the ant fights back. Not with anger, with procedure. Welcome to Dr. Mind Forensics. I've spent over 25 years across law, medicine, and forensic psychology. And everything in this series is drawn from patterns that repeat again and again in bank recovery cases across India. The names, places, and numbers are changed. The patterns are real. On one side is a family business, a working loan in good faith, with a shop, house, and even agricultural land of a relative signed as guarantor. When business slows, the account slips. The bank calls it an NPA, a non-performing asset. Now pause here, because from this exact moment, something changes that most borrowers never understand until it is too late. Under Sarfazi, the bank no longer needs to sue you. It can issue notices, take possession, and auction it. The ant is not just smaller than the elephant. The ant is standing on ground the elephant designed. When people say, "I'm fighting the bank," they think they are fighting one opponent. They are not. Watch the 4 arms. Arm 1 is the bank itself. A nationalized balance sheet, in-house law officers, impaneled advocates, and unlimited time. Arm 2, the recovery machinery. Authorized officers, enforcement agents, and sometimes men whose job description is pressure. The Supreme Court condemns muscle power recovery. Remember one line for now: a pending case is not a license to trespass. Arm 3 is the tribunal ecosystem. Debts recovery tribunals. DRTs function under the Ministry of Finance, not the judiciary. When the executive controls a tribunal's appointments and the executive's own banks are the dominant litigants, the structure has a problem. Arm 4 is the silent arm, the police. Their answer is always the same 3 words. It's sub judice. In episode 5, I will show you why those words are legally wrong and how the refusal becomes your evidence. So is it hopeless? No, because the law gave the elephant extraordinary power. It also chained the elephant. In the 2004 Mardia Chemicals case, the Supreme Court struck down the requirement to deposit 75% just to be heard. The bargain is this: the bank may act without a court, but only if it follows every step exactly. Proper service, lawful possession, honest valuation, and a 30-day sale notice correctly published. Miss a step, the sale falls. Write this down: tribunals discount indignation. They cannot discount an unserved notice. That is what wins. A tracking record showing notice returned or valuation contradicting reserve price. The ant can out-document the elephant. Here is what's coming: demand notices, vanishing notices, power valuations, muscle power, and Section 17 challenges. If you know someone facing a bank auction, share this video today. Subscribe, press the bell, and see you Monday. Remember, nothing here is legal advice. Consult a qualified advocate for your own case. Jai Hind.